please go ahead and give us an overview of the bill.
Absolutely, and it's my just distinct pleasure to be on this call with you, to be included in this process, and to have had all of the partnership of all of the groups and advocates and individuals that you mentioned. Both PowHer and Time's Up have been incredible in making this issue not only relevant but essential to take up and to continue to take up to strengthen the laws in New York. So this year we were able, and by we I mean the state Senate as well as the Assembly, with 2 Democratic majority in each house, to pass really extensive protections for all forms of discrimination, as well as sexual harassment in the workplace. So Senate Bill 6577 essentially provided increased protections, and the reason it's increased protections is because there were protections before, though rather weak, for protected classes and for special protections for employees who had been sexually harassed. So what does that really mean? What it means is that the bill, for the first time, increased protections to all employees, but it included also domestic workers and independent contractors, 2 groups that are historically left out of the conversation and left unprotected, unfortunately, but this bill protects both of those groups. It also eliminated something called the severe or pervasive standard. This is a standard that has been applied across New York State in all cases as they relate to sexual harassment. Judges would apply this standard, and oftentimes, in fact, a majority of the time, what would happen is individuals who came forward and victims who came forward would find that in a court of law, despite being brave, despite coming forward, despite having legal representation and all of their facts and evidence in place, they would not be able to have justice in the courts because the severe or pervasive standard is a very high threshold to really meet. And so by eliminating that standard, we were able to create a standard called petty slights and trivial inconveniences. This is a standard that New York City has been applying for the past 10 years, which allowed the state then to have a really great model as well as pathway to ensure that the standard applied in a very even and fair way.
Recording has started.
I'm sorry about that. Please continue.
No worries, that's fine. Technical difficulties is an unfortunate reality.
It's a reality. Thank you.
Not a problem. I still am a fan of the written words on paper, so I feel the pain. So the bill also expands and allows for punitive damages and attorney's fees in employment discrimination cases. Very important, incredibly important actually. It also increases and expands the Attorney General's enforcement powers, and it does several other things, but perhaps one of the most challenging pieces of the bill that we were able to get in, which I'm so grateful that we got in, was the prohibition of non-disclosure agreements, NDAs, that are related to discrimination. And in that vein, what it does is actually requires employers to provide the employee notice of the specific NDA. So they have to have almost like a disclaimer that this is something, that exists if there's a certain circumstance where this would exist. It also extended the statute of limitations for claims, so from 1 year to 3 years in the Division of Human Rights. Why is that important? That's important because we want our statute of limitations to reflect reality. And for those who don't know what a statute of limitation is, and I am fully aware of the fact that that could be a reality, a statute of limitation is simply an amount of time set in law that an individual can bring a case according to a specific topic that they feel that their case is related to. For sexual harassment, it was 1 year. We know that that's a very short period of time, so by extending it to 3 years, it was definitely, it expands the realities of what it takes for someone to come forward in terms of discrimination and harassment in the workplace. It also required something called the Model Sexual Harassment Policy, which is a policy that was set in the previous legislative session that is monitored and administered by the Department of Labor. It requires that that specific policy be reviewed and updated because, as we know, just creating one sexual harassment policy and document doesn't mean that it's set in stone. It's a very malleable subject that will change over time. In fact, we really hope that it will change over time because there's still terrain that we can make lots of progress on. And then lastly, it directs the Commissioner of Labor at the Department of Labor to conduct a study on strengthening sexual harassment prevention laws. One of the things actually that not in front of me, but that I want to share is that it also provides for language access, so that it's not just a policy in English. There's several different languages. We want to make sure that this is accessible to everybody. What we found when we did both of the sexual harassment hearings, which, by the way, for the first time in almost 30 years, New York held sexual harassment hearings that I was very proud to chair, thanks to the majority leader, Andrea Stewart-Cousins, who entrusted me with that responsibility. But what we heard was lots of individuals in different sectors who really felt like the legal system and the protections that it provides were inaccessible to them. And so making sure that our policies and our laws and that our websites are providing information that allow for all individuals to access them is a high priority for all of us, and luckily it was also in this specific bill.
Wonderful. Thank you so much for that explanation.